I have a revocable trust, but the lawyer gave me a will too. Why do I need a will document if I also have a revocable trust? My name is Philip Bruce. I'm an estate planning attorney in Minnesota. And you'll notice if you have a revocable trust plan, and if it was done professionally, if you're looking through your binder, you're going to see that you also have a will document. Revocable trusts skip probate. Will documents control probate. So if we have a revocable trust plan, or also called a living trust, and if we're going to avoid this probate process, the administrative court proceeding where if I die my stuff gets divided up, if we're avoiding that anyway, why do we need a will document which controls this administrative process? Wills are court documents. Wills go through probate. Revocable trusts don't. Why do we need both? And the answer, if you've done one of these plans, is with the revocable trust, its greatest strength is that anything that ends up in it, your house, your business if you have one, but your bank accounts, your car, your RV, whatever it is, anything that ends up in this thing does not need a judge in order for it to be distributed. That's great, and that's the strength. But the weakness is anything that doesn't end up in it is still subject to probate. You can't create a trust and then have it work. You got to proactively get your stuff in there. So our concern is always what happens after I've done a revocable trust plan for a client if they then buy another house. Or if they sell their house out of the trust, you can do that. You can sell your house anytime. It's still your house. If you put the house in here and you change your mind, sell it, no problem. You can do that. But then when you buy that next house, when you downsize to that condo or that townhome or whatever it is, you have to do another real estate deed to get it in here. And if you don't do that, then it's not in the trust. And if it's not in the trust, then it's not controlled by the private family agreement, the trust agreement, and we're going to need a probate. So what we always do is we do this backup, just a backup will. It's called a pour-over will, P-O-U-R, pour-over will. What it does is if something goes wrong, if we end up in this probate proceeding, well, okay, we'll go to court, unfortunately, but we'll go to court and we'll say, hey, this house, we didn't get it in the trust. So what we need you to do, judge, is follow the will. And the will says, take the house, put it in the trust. It pours over the things we forgot into the trust. That way your estate plan still works. If the trust says everything to spouse, if no spouse to kids, if no kids charity or whatever it is, that'll all still happen. We go to probate, use that as a shortcut to get the stuff in there. And there you go. That's your backup will. That's why you have both documents, a revocable trust and a pour-over will. Philip Bruce at Stone Arch Law Office. If you have any questions on any of this, please give our office a call.